Second Amendment rights are being infringed upon.
Justice's decision could impact concealed carry laws.
I was truly alarmed by the decision. In other countries, when they have mass shootings, they tighten down their gun laws.
Criminals just go get a gun, they don't care.
You're not going to solve any sort of gun violence in the city.
A federal appeals tribunal just handed down an emergency decree dismantling the heart of the concealed carry licensing structure, and not a single jurist on the bench objected. 0 dissents. The decree determined that forcing residents to secure state authorization prior to bearing arms in public breaches the Second Amendment. This is active immediately for every state within that tribunal's reach, possibly influencing tens of millions of current license holders and future applicants. I'm going to explain precisely what this implies for you, what it doesn't imply, and what actions you should take. Beginning now, if you bear arms for personal protection, hey, if you've ever sought a concealed carry license, if you've ever handed over money, endured weeks of waiting, provided biometric data, or endured questioning merely to practice a freedom already guaranteed to you by the Constitution, this decree directly impacts your existence, and here's what ought to disturb you. This scarcely received coverage. The dominant media outlets either suppressed it or overlooked it completely. The individuals obligated to inform you about this remained silent. That is precisely why we're gathered here at this moment. Your capacity to lawfully bear arms in public has shifted, and the countdown has begun on how state governments will react. The nation's highest court is currently hearing oral arguments regarding Hawaii's rigid firearm statute. The justice's verdict could reshape concealed carry statutes. Mass killings. They clamped down on firearm regulations. Okay, so allow me to guide you through what genuinely transpired and why this carries the weight it does. An alliance of firearm advocacy groups launched a federal suit targeting the entire licensing apparatus. They contended that the apparatus itself violates the Second Amendment. The litigation advanced rapidly because the central claim was simple. The state shouldn't possess the authority to force you to request consent before practicing a foundational constitutional freedom. The complainants relied extensively on New York State Rifle and Pistol Association v. Bruin. That's the pivotal 2022 High Court ruling, where the tribunal decided 6-3 that the Second Amendment safeguards a person's freedom to transport a handgun in public for personal protection. Bruin created the historical text and tradition evaluation. That signifies any contemporary firearm restriction must align with the historical customs of firearm governance. At the moment the Second Amendment was adopted. That's the legal benchmark today, and it's precisely the benchmark this bench employed. The tribunal scrutinized the history of licensing apparatuses in this nation and measured them against what the framers envisioned. The prevailing opinion concluded that the existing licensing structure surpassed what historical documentation could substantiate. In straightforward terms, the tribunal declared the structure overreached and they terminated it. Every jurist on the bench concurred on the central finding. A unanimous verdict on a Second Amendment matter at the federal appeals level is extraordinarily uncommon. It reveals how overwhelmingly lopsided the legal reasoning was. Major developments emerging from the Supreme Court this morning, revealing it will hear a significant Second Amendment matter. They never volunteered for this. They reject this freedom. They refuse to endure additional firearm violence beyond what they currently face. Now here's where I require your undivided attention, because this is the segment that genuinely alters your everyday existence. Prior to this decree, if you wished to carry concealed in public, you needed to navigate your state's bureaucracy. You completed paperwork, underwent vetting, forked over payments, and in certain states, you lingered for months. Some states functioned under what's termed a may issue model, that signified regional authorities, such as your county sheriff, wielded extensive leeway to reject your petition for virtually any rationale they desired. Examine your history, your expressed justification for wanting to bear arms, and arbitrarily conclude you failed to establish sufficient necessity. That's the identical structure the Supreme Court abolished in Bruin, and this decree hammers that point home even harder. What this tribunal declared is that the state cannot predicate the practice of a constitutional freedom on an administrative green light procedure. The obligation has reversed. Previously, you needed to demonstrate to the state that you're entitled to bear arms. Now the state must demonstrate there's a particular legal basis you shouldn't be permitted to. That's a profound transformation in how your freedoms operate in reality. To secure a license to bear arms, you needed to furnish them with a justification for why you required it. But let me be candid with you regarding what this decree fails to accomplish, because there's considerable misinformation spreading across the internet at this moment. This decree doesn't signify you can bear arms any place without limitations. Federal statute under 18 U.S.C. section 922. That is, the federal prohibited person statute remains intact. If you're a convicted felon, if you've been ruled mentally incompetent, if you belong to any of the barred classifications, this decree doesn't alter your standing. You remain barred. Furthermore, statutes dictating where you may bear arms still hold. Federal structures, educational institutions under the Gun-Free School Zones Act, that is 18 U.S.C. Section 922Q transportation hubs, judicial facilities. Those constraints stay in force. This decree tackles who may bear arms. It doesn't reconstruct where bearing arms is allowed. Those are entirely distinct legal inquiries. Here's the additional element you must grasp. This decree binds directly to states inside the issuing tribunal's territory. It doesn't instantly extend to all 50 states, however, and this is crucial. Additional federal tribunals are observing. There are lawsuits queued nationwide that have been anticipating precisely this type of precedent. Matters like Bianchi v. Brown in the Fourth Circuit, contesting Maryland's assault firearm prohibition, cases progressing through the Ninth Circuit following Bruin challenges to Illinois' Protect Illinois Communities Act, that is SB 22286, the state's assault firearms and magazine prohibition. When a decree this forceful arrives with zero objections, transmits a message to every other federal bench weighing comparable challenges. The momentum here is advancing in a single trajectory. The country's top tribunal has ruled that citizens possess a freedom to bear firearms in public for personal protection. Possessing the decree that the Supreme Court delivered today, being capable of safeguarding yourself, safeguarding your household doesn't cease at your threshold. Now, permit me to address the cascading consequences that will unfold throughout the approaching months. Initially, states falling under this decree will panic. Some will conform and start dismantling their licensing apparatuses. Others, and you recognize which ones I mean, will attempt to ram through emergency statutes, crafted to produce an identical outcome through alternative legal phrasing. They'll rebrand the license, reconfigure the payments, label it a safety credential instead of a carry authorization. Pray the tribunals overlook it. Tribunals will notice, and those fresh statutes will confront immediate legal challenges, invoking this exact decree. Secondly, federal bureaus will need to adjust. The ATF, the FBI, and agencies that depend on state license information for background monitoring and enforcement constructed their apparatuses around a framework that just got destabilized. When states cease issuing licenses, those bureaus forfeit an information channel they've relied upon for generations. Currently, Michigan residents must secure a license to carry a concealed firearm with a base charge of $100. Empire State barred individuals. They aim to bar individuals from bearing weapons in public. State statute limits open carry licenses to solely counties with populations beneath 200,000 residents, rendering the concealed carry licensing procedure more lenient. Or you're not going to fix any firearm violence in urban areas. Thirdly, if you journey between states with your firearm, your circumstances just grew substantially more complex in the immediate future. Not every state falls under this decree yet. State constitutional clauses function autonomously. You must know the particular statutes in every state you traverse, not merely your home state. The legal landscape of where you may bear arms will appear dramatically altered in half a year. Present understanding may already be obsolete. So is this an absolute victory? No. Let me be frank with you. The decree is robust, it's unanimous, and it's anchored solidly in Bruin. But the judicial process is nowhere near concluded. There will be appeals. The defeated faction will request an en banc rehearing. That entails petitioning the complete circuit court, not merely the panel, to re-examine. Should that fail, they'll petition the Supreme Court for certiorari, that is, requesting the tribunal to hear the matter. Considering that Bruin already established the framework this decree depends upon, I'd estimate the probability of a successful reversal at perhaps 15 to 20%, but 15 to 20% isn't nil. In the interim, states will deploy every resource at their disposal to maintain their grip over who may bear arms. The tribunal is anticipated to rule on a fresh statute prohibiting high-capacity magazines. Justice Clarence Thomas recently, who indicated he believed the tribunal currently viewed the Second Amendment matter as a disfavored freedom. When we practice our freedom of worship, we aren't compelled to secure a license or authorization. If you're a civilian bearing a firearm, you're a villain, and so I believe this resolves that your accountability has likewise expanded. More individuals will be lawfully armed in more locations. That elevates the stakes for every firearm proprietor to train adequately, to comprehend use of force statutes, and to bear arms with the discipline this freedom necessitates. Don't permit anyone to exploit this decree as justification for recklessness when you bear arms. You embody every individual who practices this freedom. Conduct yourself accordingly. State prohibitions on assault firearms, and the Supreme Court is at this juncture sidestepping the conflict. We believe the freedom to possess and bear arms shall not be violated. Period. The Supreme Court declared that the Second Amendment indeed confers an individual freedom to possess a firearm. In 2024, a Cowlitz County jurist overturned the statute, but the Washington State Supreme Court sustained it. Armed individuals are frightened for their survival. They're going to retreat from wickedness. Here's your current status update. The decree is enforceable. It hasn't been suspended or overturned as of today. Your current license isn't useless because it may still benefit you in states outside this tribunal's territory and during encounters with law enforcement. Still functioning under the previous framework encompasses the vending, importation, fabrication, paint, and circulation of these magazines containing more than 10 rounds. A significant victory for firearm safety proponents. The Supreme Court will not entertain a challenge to Maryland's assault firearms prohibition. High-capacity magazines aren't essential for personal protection and are habitually employed in mass killings. If you reside in a state under this tribunal, you're no longer legally obligated to secure a license to carry concealed, but you must still adhere to all other applicable federal and state statutes concerning where you bear arms and whether you're a barred individual. Monitor your state legislature vigilantly throughout the next 30 to 60 days because emergency statutes are approaching. Hey, I'll be reporting every single development as it unfolds. That's all for today, folks. Catch you in the next video.